Hi, everyone. Thanks for joining us. My name is Brett Bussell. I'm the managing partner here with ACA Prime, and I'm excited to introduce our ACA attorney here from Ogletree Deacons, Stephen Riga, who'll be walking through various topics around the ACA mandate for 2022. So with that, go ahead, Stephen.
All right, great. So, first and foremost, the important thing to keep in mind is the ACA in 2022 has been relatively quiet. There haven't been Supreme Court decisions or attempts to repeal in the current Congress, but there have been a few recent updates that you should be aware of. And I think generally speaking, the main trend right now is towards increased enforcement. So this is something which, based on some of the news that we'll discuss, is something that we can expect over the next few years in particular. And I think we're already seeing what that looks like. So let's start with a discussion of the affordability standard, because this is one of the things that it has essentially been updated significantly, and this update actually has real world implications. So you may be aware that essentially when it comes to the ACA mandate, an employer is obligated to make an offer of coverage that meets minimum necessary or minimum value and is affordable. And the affordability threshold is based on essentially inflation, medical inflation numbers. And what happened in August of 2022 is that the 2023 numbers came out. And the surprise here is that the number set for a threshold for affordability this year is set at 9.12%. That threshold is significantly lower than the 9.61% set for 2022. It's the lowest percentage that has ever been set for the affordability standard. And what this really means is for employers is that the amount that an employee can be expected to contribute for their coverage is a lower threshold than it has been in prior years. So 9.12% is a significant drop down from that 9.61%, which means you can charge effectively a smaller amount of their total income, or depending on your calculation method, the proxy for that. Employers have a variety of methods that they can use for determining affordability. And what is important to note, while this is a significant drop of the affordability threshold, the reality is that some of the other numbers that are used for the safe harbor calculations have significantly increased. So for example, the federal poverty level, which is one of the methods that is used for determining what is affordable, has had a significant increase, meaning that in a lot of cases, the affordability threshold, when calculated with the other numbers that are used to make a determination about affordability more generally, are essentially a wash. And so the actual dollar amounts that you can charge an employee have not really radically changed. But this percentage does suggest that there's at least some opportunity for additional individuals to be determined to not have affordable coverage based on the amount that is being charged them for that coverage. Now, let's go to the next element in this, and there are changes under the Inflation Reduction Act that actually impact this calculation, because one of the things that the Inflation Reduction Act did was it increased subsidies, or it increased, it extended the increased subsidies that have been in place for the last couple of years. They extended them for another 3 years into 2025. Being that this is the set of subsidies are the dollars that an individual gets if they enroll in marketplace coverage under the ACA. This is important for employers in particular because this eligibility for subsidies, when someone enrolls and gets a subsidy, that is the trigger that results in assessments under the ACA's employer mandate. So when you combine the affordability standard being reduced with the continuation of the increased subsidies under the Inflation Reduction Act, you end up with a situation in which the threshold for a trigger for some of these assessments has gone down, and the trigger is actually more common because more people are getting the subsidy. Together, this produces a situation where you can expect that there should be some increase in assessments. Another element under the Inflation Reduction Act that's important to keep in mind is that the law also increased the IRS budget, meaning that the service is likely to pursue further enforcement because they have the money to do so. They can establish new initiatives to drive enforcement and compliance with various laws that perhaps they had less of an ability to do so in prior years because they didn't have the money to make that program happen. Now, what does that look like? Well, employers and corporate organizations in general are expected to be one of the main targets for this additional enforcement. And why is that? Well, it's kind of like that story about banks being where, why do people rob banks? It's where the money is. Well, why does the IRS go and investigate corporate organizations? It's because that's where money is. So assessments under the Affordable Care Act for the employer mandate is one of those places where there's at least some opportunity for significant new assessments and new opportunities to recover funds. So not only just in the question of the actual employer mandate under the A and B penalties that we're used to, but also under the assessments that exist for late or inaccurate returns, which can result in hundreds of dollars of liability per person whose returns aren't properly filed or filed late. All of this points to the idea that we can expect to see the IRS engaging in a fair amount of additional enforcement in the coming years. So I think it then becomes important to think a little bit about what does enforcement really look like in this particular environment. What does the IRS do, and what can employers do to try and address the issues that are involved? So I'm going to walk you through a set of experiences that I've been dealing with recently with a current client of mine. And just to start out, it's important to understand that the errors here on the returns that we're talking about didn't relate to an enforcement action pursuant to a failure to actually extend coverage. Coverage was extended to their full-time population. The issue was there were certain errors in the returns when they were completed and filed. And specifically, there was a no checked on the offer to 95% of employees when it should have been a yes. The end result was that for 2018 and 2019, the IRS came out with positions that said that this client owed over $13 million per year in assessments. Now, this is a fairly large employer, several thousand employees, but obviously $13 million to any employer is going to really get your blood flowing a bit. In addition to these huge assessments for under the employer mandate, there was also an assessment that was imposed ostensibly for a late filing. And that assessment in 2018 was for approximately $250,000, give or take. Together, our client was understandably quite concerned by what the assessment documentation was saying, but unfortunately for them, there was a critical delay because these assessments during COVID got lost in the corporate mail and didn't get to the people who were responsible for both dealing with the actual form submissions and dealing with the benefits and the provision of benefits for this client for actually almost a year and a half in the case of the most early proposed assessment. So there was a significant failure on this client's part of getting the documentation in a time frame to be responsive. And I think what you see in the different incidents and the different stage that each of these assessments was in is instructive in giving you an idea of kind of what you're really facing as an employer, depending on when in the process you actually start to respond. So first off, the Act 1, if you can respond to a proposed assessment, or even better, if you can get your returns in on time and correct, the answer is you can generally reduce to almost or to a minimal situation the amount of exposure that's involved. Because if you get your returns in on time and they're correct, essentially the only situation in which you should be assessed is if you actually had a failure to offer the coverage the way you were supposed to offer that coverage. That isn't always true. In my experience, you can do everything right and you still can end up with an assessment. But then that second part of it is, if you respond promptly, it is straightforward enough to get the information into the hands of the IRS to make this issue go away. So I think first step in this is to make sure that your communication system and the information associated with your plans and the address, for example, that is in your 5500 documentation is such that you make sure that that information gets channeled properly, so that if you get a proposed assessment, that isn't getting lost in the mail, isn't getting sent to the wrong person or someone who's left the organization literally years ago. Quick response here is going to make the likelihood of an actual assessment that produces an attempts at recovery by the IRS much less of a likely problem. So just because the IRS moves from a proposal to actual assessment, Act 2, do you have some defense or documentation that can produce a good result? If the answer is yes, even if the assessment has been entered for you organizationally, you still have the ability to submit the information. For the client that we were working with, we had 2018 and we had 2019 assessments. Well, the 2019 assessment had come in significantly later, obviously, because it was for 2019. And so when all of this information came to our client's desk, the people who are really actually dealing with this problem, the delay was such that we could go and promptly respond to the assessment before it was entered into collections and provide the necessary information for the IRS to say, okay, yeah, all right. Yes, the information on this return was incorrect, but the reality is the ground for the assessment was based on the penalty that would be imposed because you didn't actually provide an offer, but you provided information necessary to evidence that you actually did provide the offer. You just provided information that was incorrect on the form. So the IRS came back with the 2019 assessment and said, that information makes sense. That information is sufficient for our purposes to withdraw the assessment and to resolve the $13 million liability for 2019. Good result. And that closed about 3 months after the submission of that additional information. Contrast that with Act 3. Our collection actually has begun. And in that situation, several things were really impacted. First, it took significantly longer to get to ground with the IRS about producing this information and saying, and getting them to sign off and say, okay, yeah, we don't have a liability. We just got word that the IRS is accepting our correction of information and that they will withdraw the assessment. But even with that as the status, we had to work with the client to submit a Form 84 or 843 in order so that we could get a refund of the monies that were already being withheld from refunds and other amounts were supposed to be paid to the client and had been instead taken away because there was this assessment sitting out there in collections. In the end, we fully expect to be able to get all of those monies returned, but it's taking time, and it's taking time for the client. It's taking billable time for us to process and submit these forms and to work with the IRS and have conversations to get this taken care of. Money and time that if this hadn't gotten lost and the response had been sooner, we wouldn't have had, the client wouldn't have had to incur that. At the same time, this client also got that assessment for late filings. And again, that was delayed in response, producing a situation in which the client had moved from assessment to collections. Now, this was a relatively small group of this client, and only a few hundred late filings were involved, ostensibly. But that produced an assessment north of $250,000. So these things stack quickly, and at over $800 per person at this point. So you're faced with a situation in which even if you actually weren't late, the dollar amounts can get quite extreme pretty quickly, even with a fairly small group of people. For this client, for this situation, the documentation is pretty clear. And yet we're still waiting to get an IRS response on this particular assessment. It wasn't exactly easy to figure out what the problem was, because when we got the assessment, it didn't even reference the fact that it was because of ACA reporting. It was only based on the reality, which was we were already dealing with other assessment situations that we thought it likely was all of a piece. But it turned out that the trigger was different because it was an assertion that the assessment or that the returns were late. And therefore the assessment documentation that was needed was significantly different. In the end, I think there are a few basic takeaways that you need to be thinking about when you're engaged in trying to keep your risk of IRS assessment for ACA penalties to a minimum. And I think first, whether we're talking about the actual returns, or we're talking about potential assessments, the sooner you can respond, the better. Certainly being late might cost you, as that last assessment pointed to, but being late is almost always going to be better than not filing at all, because effectively in a situation where you're not filing, there's a risk that you might be determined to be willful in your non-compliance. And that willfulness can produce a situation where your assessment might be doubled. All which is to say, late is still better than never. And certainly if the IRS is proposing a penalty for you, what you need to do is not get too concerned or worried about the fact that there might be an eye-popping number. Work the system, work the documentation. Often the number that is initially assessed is the worst case scenario. And a lot of times information that you provide can reduce or even eliminate that potential liability. So it's in your best interest to get a potential assessment and jump on that right away and work, to get a response in as soon as you possibly can. So that finishes my my comments on the ACA in 2022. As always, hope that was useful information and that you had some good takeaways from that. Thank you.
Thanks, Stephen. Definitely good stuff, and respond in time. Don't ignore the IRS letters. Make sure you're receiving them, and do it accurately and in a timely manner. And generally speaking, we always say, act in good faith, and get it done right the first time and on time is also a good idea as well. So, well, thank you so much, Stephen. We appreciate it, and thank you to all our viewers. And please reach out to us if we can answer any further questions specific to your employer or situation.